School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Presenting Block 1 Overview of Business Law. Unit 1 Introduction to Business Law Part 2.
Scope of business law. For a better understanding of business laws and the scenario giving rise to their emergence, it is imperative to understand the frame of societal reference which gave birth to this branch of law. Any study of business law must necessarily provide major thrust to the rules framed in relation to business law because society has imposed constructive notice of that law. Understanding the background sheds light on the reason behind the emergence and the functioning of a particular law and shall aid in making policies that might prove beneficial in the long run. The scope of business laws is very vast. It takes into its ambit the laws related to all the activities proving indispensable for the successful conduct of the business. The scope of business laws is not restricted to the laws related to companies, but it also provides laws for business activities conducted by other forms of business organizations. There are laws to deal with contracts, property, agency, negotiable instruments, sale of goods, bailment, guarantees, intellectual property, etc. In relation to companies, there is multitude of laws such as corporate laws, security laws, competition law, foreign exchange laws, tax laws, etc. Right from the incorporation of a business entity till it attains finality, numerous laws are provided for every significant act that may be resorted by a business entity throughout its life. There are a range of laws that have been enacted for the proper commencement of business activities for the required conduct during its life cycle, with finally laws laying down procedures directing the regulation and culmination of the business activity in question. Business law also aids in raising questions against governmental regulations in case it results in violation of legitimate business practices. The legal consequences of the multifarious business transactions also play a significant role for the accountant of the company in auditing the company's books and in the course of preparing required financial statements. Business laws also subserve the interests of society at large. Laws dealing with insurance, environmental protection, taxation, etc. are extremely beneficial for the promotion of rights and interests of the general public. Antitrust law, which also forms an important part of business law, keeps a check on market concentration, monopolistic and oligopolistic companies, along with the dominance exerted by these companies in the market. Government also facilitates business transactions wherever it is required in the best interest of the company. The government had invested bids for the Air India divestment process, for which the Tata Group and SpiceJet promoters have submitted bids. The government has decided to offer 100% stake in the debt-ridden state-run airline this time. This has been done after Air India had failed to attract any bidder when the government had offered a 76% stake in the former 3 years ago. Corporate restructuring under business law. Corporate restructuring also forms an essential part of the business development. Corporate restructuring is a process whereby a firm looks to enhance its shareholder value. It encompasses a broad range of transactions within its ambit, including within its purview, changing its capital structure through the infusion of high levels of debt to selling of business lines or making acquisitions by taking over corporations and making internal changes in the organization of the firm. It is an absolute necessity for a company's basic survival or sustenance in the corporate sector to combat multiple competitors in the market looking to dominate. There are numerous ways by which a company may look to restructure its business, viz. Merger and amalgamation, merger through absorption, merger through consolidation, acquisition, takeovers, divestiture, demerger, joint venture, and buyback of securities, to name a few. There can exist multiple reasons for a company to opt for internal or external restructuring, such as to focus on core competency, for hiving off assets, eliminating competition, achieving economies of scope and economies of scale, gaining access to R&D and technology know-how, synergistic effects, diversification, and enhancing public perception. These different forms of restructuring are also supervised by different branches of business law, such as Companies Act, FEMA, taxation laws, SEBI Act, to name a few. One recent example of a company engaging in restructuring in the form of acquisition as a means to expand could be the case of EdTech giant Byju's, which is looking to achieve success in K-12, that is, kindergarten to 12th standard online education. Byju's has already engaged in multiple acquisitions, including Medical Coaching Institute Akash, Epic Games, Great Learning, Scholar, GradeUp, to name a few, spending close to $2 billion for the same in this year. Byju's has recently made its 9th acquisition of the year when it acquired Tinker, a Silicon Valley-based coding platform for children, for an estimated amount of $100 million, also its 3rd acquisition of a US-based company. These slew of acquisitions by the company have been made with a view to obtain a public listing in the US. The phenomenon of M&A is governed by legislations such as Companies Act, SEBI Act, and its substantial acquisition of shares and takeover or SAST regulations, among others. Most of the current dialogues about corporate governance can also be attributed to discussing a corporation's existence and for whose interest the corporate exists and ultimately serves. Most commonly, the obvious answer is the maximization of wealth for the shareholders of a company. The principle of shareholder wealth focuses on the aspect of cash flows that may not be immediate profit generating and more of a future outcome. A company aims to amplify the residual profits that remain after all the incidental costs are reduced. Profit generation may not be the only aim of a company, but it may prove to be a significant reason. From a shareholder's perspective, in a competitive and flourishing market, anything a company does to enhance share prices is a plus. Moreover, whenever shareholders do activities such as selling, buying, or retaining their shares, it adds to their value. Sources of business law. There are many sources from which the business law evolves. Some of the main sources are: number 1, Constitution. The text of the Constitution, along with its interpretation by the Supreme Court from time to time, is considered as the supreme law of the land. All laws and authority flowing from and traceable to the Constitution are recognized as lawful power. The Indian Constitution establishes the fundamental principles and rules by which the individual states are governed. The term constitutional law refers to the general limits and powers of the central and state governments as stated in written constitutions. The Indian Constitution is the supreme law of the land, and all the laws of the country have their foundation in the Indian Constitution. The Indian Constitution was drafted with certain objectives that were latent in the text and provided directions to the state to achieve a social order for the upliftment and welfare of the people. Even otherwise, Post the 42nd Amendment, the preamble of the Constitution was incorporated with the terms socialist and secular, which strengthened the objective to promote social welfare. Article 38 places the responsibility on the state to strive to promote the welfare of the people by achieving a social order, while Article 39 provides for a few principles of policy to be observed by the state. Article 38 and 39, though having been placed in Part 4 of the Constitution as directive principles of state policy and cannot be enforced in a court of law, prove extremely significant, laying down directions for good governance of a state. Especially, it directs the state to frame policies that ensure that the ownership and control of the material resources are adequately distributed and that the operation of the economic system must not lead to a concentration of wealth to the common detriment. For instance, the Government of India ordered the formation of a committee, that is, Mahalanobis Committee, to assess the income distribution in the society due to the rising monopolistic and restrictive trade practices that were being observed in the country. This led to the formation of the Monopolies Inquiry Committee, and the report submitted paved the way for the Monopolies and Restrictive Trade Commission Act, that is MRTP Act. This way, the Constitution of India, specifically Article 39, sowed the seeds for the genesis of competition laws in India. Article 19(1)(g) of the Constitution guarantees that all citizens shall have the right to practice any profession or to carry on occupation, trade or business. The right to carry on a profession, trade or business is not absolute. Reasonable restrictions can be imposed by the state in the exercise of such right. Part 13 of the Constitution deals with trade, commerce and intercourse within the territory of India. Article 301 provides that subjected to the other provisions of this part, trade, commerce and intercourse throughout the territory of India shall be free. Article 302 gives power to the Parliament to impose restrictions. It says that the Parliament may by law impose such restrictions on the freedom of trade, commerce or intercourse between one state and another or within any part of the territory of India as may be required in the public interest. Number 2. Statutes. A statute can be defined as an act of the legislature in written form. Legislative actions called statutes are another important source of law. The assortment of rules and regulations put forth by legislatures is what we call statutory law. The Parliament and the state legislatures have been conferred the primary responsibility to enact laws as per the requirements of the Union and the state respectively. Legislation is the common source of law. Both Parliament and state assemblies have enacted a number of legislations that cover various aspects of business. The act of creating laws, also known as legislating, cannot solely be performed by the Parliament due to the enormous number of legislations required to run a state. The act of legislations can be delegated to subordinate authorities such as executive bodies and individuals by providing the necessary guidelines, policies and rules that must be resorted to while laying down the law. This area of legislations is also known as delegated or subordinate legislation. The legislature has come up with various laws to counter the issues cropping up in the business administration in our country. Number 3. Cases. Case laws play an important role in shaping the law and bringing out its relevance as per the prevailing conditions in the society. The interpretation offered by the judges in the form of ratio decidendi aids in clarifying the nuances of the law. Judicial decisions in the form of precedents are one of the most important sources of law. Case laws, constitution, legislatures, and administrative agencies encourage certain behavior and prevent other actions. but the boundaries of these laws are seldom self-explanatory. Consequently, law must be interpreted. Case law is the collection of legal interpretations made by judges. An alternative name for case law is common law, as common law is a judge-made law. Interpretations provided by courts in cases are laws unless they are revoked later by new statutory law. Case law is especially significant for businesses because a modern business often operates in multiple legal jurisdictions. Because statutory laws are subjected to interpretation, one court may have interpreted laws one way at one business location, and a second court may interpret a similarly worded statute differently at a second business location. Courts issue judicial decisions that often include interpretations of statutes and administrative regulations. These decisions contain the reasoning the courts use to arrive at their decisions. The reasoning depends heavily on precedent, the use of past decisions to guide future decisions. An earlier decision in a similar fact pattern is a precedent that guides later decisions, thereby providing greater stability and predictability to the law. Number 4. Custom. Custom is one of the most important sources of law. It is possible to detect two basic elements in the makeup of the custom. Number 1. Material facts. This is the actual behavior of states founded upon the performance of the state activities and practices. And number 2. Psychological element. This is the belief by the state that behaved in a certain way, that it was a legal obligation to act that way. There are a number of factors concerning the nature of a particular practice, that is, duration, repetition, consistency, and generality. A substantial part of business law is customary, notwithstanding advances made in science and technology. This is true both in developed and developing countries. A custom, when accepted by courts and incorporated in judicial interpretations, becomes a law. Many of the business customs or usages have already been adopted and legalized. The Indian Contract Act provides that nothing therein contained shall affect any usage or custom of trade. Similarly, the Negotiable Instruments Act provides that nothing therein contained shall affect any local usage relating to instruments in an Oriental language. Number 5. Treaties. Treaties are a source of international business law. They are one of the sources that have been mentioned under Article 38 of the Statute of the International Court of Justice. Treaties are obligatory in nature and are founded upon the customary principle that agreements are binding upon the parties and must be performed in good faith. For many writers, treaties constitute most important source as they require the express consent of the contracting states, and they are thus considered superior to custom. The consent to a treaty can be signified by signature, exchange of instruments, ratification, or accession by the concerned countries. The purpose of international laws is to permit countries as much authority as possible over their own international business affairs while maximizing economic benefits of trade and working relationships with other nations. Since many countries have historically allowed governance by international agreements when conducting global business, there exists an evolving body of international laws that facilitate global trade and commerce. A treaty is similar to a contract in two important ways. Both treaties and contracts are attempts by parties to determine rights and obligations among themselves. In addition, when a party fails to obey a treaty or an international contract, international law imposes liability on that party. Treaties can be multilateral, that is, signed amongst many countries, and bilateral, that is, existing between two countries. And number 6 is government policies. The legal power to make laws comes to the government from the Constitution. Laws are framed according to the policies of the government. One can understand the focus of any government through its policies. For example, when the focus is to promote ease of doing business, the government accordingly brought new legislations and regulations to remove bottlenecks which had increased time consumed in contracts enforcement. Similarly, the economic reforms undertaken, provision of easy financing for MSME sector or women entrepreneurs, bringing new policies like e-commerce policy, etc., are examples of government intervention for regulating the business through policies. Laws are made according to the policies. Now let's summarize the unit. Understanding the basics of business laws are extremely important for the students of business management stream to get a firm grasp on the concepts and gaining deeper knowledge of the subject. This unit focuses on defining the meaning of business, the scope and significance of business law in the current economic scenario, and to explain the different sources of law which contributed in the evolution of business law. A business can be defined as an enterprise or organization involved in an industrial, mercantile, or commercial activity. A business entity may be brought forth for a profit purpose, or it can serve non-profit purposes supporting a charitable or a social cause. A business may also be referred to the activities of an individual or a group of individuals engaged in the sale of goods and provision of services with a profit motive. Business law is that branch of the legal system which promotes an orderly treatment of business affairs, facilitates the regulation of commercial activities in accordance with established practices of law, and provides for settlement of disputes in an amicable manner. It constitutes that part of the legal system which is most fundamental to national wealth creation. It also specifies the rules and the conduct that needs to be adhered to for the creation of successful business relationships among the government, business entities and the public, and business enterprises inter se. Business law also aids in establishing the environment needed for responsible and peaceful business dealings, not just amongst the different enterprises, but also for safeguarding the rights of the employees. Business law also requires understanding and firm grounding of multiple substantive areas of law. There are many sources from which the business law evolves. Some of these main sources are constitution, statutes, cases, customs, treaties, and government policies.
We were listening to the audiobook by the School of Management Studies IGNOU for MBA program. Course code MMPC-013 Business Law. Course coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.